Welcome. Today, we'll be discussing the rights and procedures surrounding child witnesses in New Zealand jury trials, based on the Evidence Act 2006. When a child is called as a witness in a criminal proceeding, they have specific entitlements regarding how they can give evidence. Key points to remember. 1. Child witnesses are entitled to give evidence in one of the ways listed in Section 107(1) of the Evidence Act 2006. 2. As long as procedural requirements are met, the child can give evidence in the proposed manner. 3. Applications can be made for the child to give evidence in the ordinary way under Sections 107A and 107B of the Evidence Act 2006. Section 107 creates an entitlement for child witnesses to give evidence in specific ways. This means an application can be made for the child to give evidence in the ordinary way if they wish. If a party intends to call a child witness, they must provide written notice to all other parties and the court. This notice must include the alternative ways the witness will give evidence. The judge does not decide whether to allow the child to give evidence in the proposed way. If the party calling the child complies with Section 107 in the Criminal Procedure Rules 2012, the child is entitled to give evidence in that manner. The alternative ways of giving evidence are outlined in Section 107(1). These include video-recorded testimony made before the hearing, or while in the courtroom but unable to see the defendant, or from an appropriate place outside the courtroom, either in New Zealand or elsewhere. Section 106 sets out pre-trial requirements for video record evidence. It's important to note that a child under 12 is not required to give an oath or affirmation. Instead, they must be informed of the importance of telling the truth and promise to do so, as stated in Section 77. In summary, New Zealand law provides specific protections and procedures for child witnesses in jury trials, ensuring their comfort and fair treatment.